Good afternoon. I am Matt Brinckerhoff. I have for 3 years now been representing about a dozen home and business owners within the footprint. And as of today, now almost a little more than 3 years after this case started, we have lost the first step in a multi-step process of defending these homes and businesses. We have the next step is for the Empire State Development Corporation to commence a proceeding against the plaintiffs in this case to actually attempt to seize their properties formally and legally. And we will be defending that vigorously over the course of the next coming months and years if required. And we also want to announce today our intent, based on the decision of the Court of Appeals, to file a lawsuit next week seeking to compel the Empire State Development Corporation to make new or amended findings of public use. The Court of Appeals made it clear today that it was constrained by the record that was created in 2004 and 2005 and could not consider any of the new circumstances that have occurred, particularly over the course of the last 3 or 4 months, namely the fact that there's a new modified general project plan that was passed 2 months ago, that the IBO has issued a report determining conclusively that this project is a net money loser of hundreds of millions of dollars for the city of New York and millions for the state, that the rail yard that was supposed to be upgraded and was one of the public purposes that the state has relied upon is now going to be diminished and downgraded, that the amount of money received by Ratner by the MTA has also been diminished over time. The Court of Appeals made it clear that it was not and could not consider any of those things. So we will file a case next week to compel the ESDC to consider those issues and to issue new determination and findings. And once they do that, we will start this process over again. So we've lost round one. This is a multi-round fight. And obviously we're disappointed that we lost round one, but there are many left to go. And so we're still hopeful and optimistic that in the end, all of these properties, the one behind me, Mr. Goldstein's condominium, the businesses owned by many of the other plaintiffs, including Mr. Weinstein, who's standing here right behind me, will ultimately be protected by the courts through our cases in this process. And that's just on eminent domain. It obviously doesn't include the other cases that Daniel Goldstein referenced, which also are challenging the project as a whole. The procedural irregularity that we can raise in defense, right, is the fact that the findings are based on facts that were found 3 years ago, and they have refused to reconsider them or to even analyze them in the first instance. So you're saying it's the same argument in service of two different things, right? The argument is that everything was frozen in December '06 and things have changed, and you know as well as anybody all the things that have changed, right? And that has two consequences. The first is it gives us a defense to the Article 4 proceeding, because as a procedural matter, those findings and the taking that is occurring now are based on facts that no longer exist, one. And two, it gives rise now to a claim that we can bring against Empire State Development Corp. to basically get an order to compel them to amend their findings.
So you're saying that what is typically non-problematic, which is the act of proceeding with condemnation, can be challenged in a new way?
Yes.
Okay.
Yes.
Opinion today, because you did ask them to consider stuff.
We did.
Like, what was the reason for denying it?
They didn't give a reason. All they said was that they were bound by the record that existed prior to the findings.
And are there any other eminent domain cases that have changed over time that have, in a similar situation that then
No,
be
but
challenged?
to be fair, there's no claim almost that we've raised that hasn't. The answer is not that I'm aware of.
There was one thing that was not addressed, I think, in the decision this morning was the balancing of public and private.
They ignored it entirely.
That's okay.
Yeah.
And you think they should not have done that?
I think they should not have ignored it. I think that they should not have found that slums means slums in 1938 for one purpose, but not for another, which is a pretty clear import of their decision. There's a very serious disconnect. I'm sure you may have noticed they said for purposes of eminent domain, slums now mean anything that looks bad. But for purposes of Section 6, slums only mean what slums were in 1930s. It's the same language and the same provision in the Constitution, interpreted one way for one purpose and one way for...
What do you want ESDC to do? Did they do anything wrong the second time, aside from the kind of other cases?
Well, they should have. I mean, listen, what they should have done when they modified the general project plan, and when they realized that many of the public benefits that they were relying on to take these properties had changed, they should have, on their own initiative, amended this. But they haven't, so now we'll try to get a court to order them to do it.
Didn't they do, and the kind of due diligence in that they did another economic analysis?
Right, but what they didn't do, and there's a reason they didn't do it, is it's one thing to issue a modified general project plan, which doesn't trigger a whole new set of rights, at least arguably, but there are a lot of lawsuits out there fighting over this, so that's one issue. But if they issued new EDPL findings, they know that they would restart the clock back to December 2006, and we'd be starting all over again, which is what will happen if we get the court to order them to do this.
If the court today found that, the big thing was that they found that ESDC's determination of blight, if I was reading right, ESDC's determination of blight was something that they'll defer to.
Yes, they did.
Why would that have changed between 2006 and now?
Because their determination, well, it's not just determination of blight, I'm sorry, it's their determination that there's a public benefit here, right? Not just blight. Right. And so while, the reality is, I think we all understand that if anything, this area is considerably more blighted, whatever that exactly means, than it was 3 years ago, or more importantly, 6 years ago. The public's benefit of getting rid of that blight, remember, they didn't just cite blight. That was one small thing they cited. They also cited a whole lot of other things, many of which have been undermined or have disappeared.
So the reason I was asking about an injunction is, I mean, it seems like by the time a case like this would wind its way through the courts, they would already be into, if not well into the condemnation process. So I guess the question is, how do you stop that before it happens, as opposed to...
Well, that's why we're raising this specific argument in two ways. One is an affirmative case to get them to order the ESDC to make a new or amended finding, and the other is using the same issue, meaning the fact that these findings are stagnant and fixed and are 3 years old and don't consider all of these new things. We're going to also be utilizing that as a defense to the action that they presumably will now bring to take the property.
Okay.
And so we don't need an injunction to stop the project or to prevent the properties from being taken if we're successful in defending the taking of the properties on this ground.
So